The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. The next case is State versus Parker, and we will hear from the appellant.
Mr. Chief Justice, Associate Justices of the Supreme Court, my name is Michael Casterline. I'm here on behalf of Brandon Allen Parker, the appellant in this case. I would like to reserve 8 minutes for rebuttal in this argument. First thing I would like to talk about, this is a case involving closing arguments. Facts of this case are that during the closing argument of this case, Brandon Parker, who was convicted of possession of a firearm by a felon, an habitual felon, prosecuting attorney 3 times during closing argument made direct and explicit misstatements of facts that involved putting words in the mouth of eyewitnesses to this crime. This went to the material and the most important issue in the case, as the prosecuting attorney's closing remarks said. The bottom line in this case is who is the identity of P, the man on the porch, and then 3 times during closing argument described an eyewitness as having testified that P was the man on a tattoo. There's nothing in the record to support that at all. And in fact, the Court of Appeals opinion calls this a repeated invocation of mistaken eyewitness testimony, an erroneous summary of the evidence. But to be clear, it is a false representation of material facts. It is attributing a statement to the witness that the witness never made. It's made repeatedly to the jury in this case, and we contend that that is grossly improper argument. There was no objection in the trial court to this by the defense counsel, but what we have here is under the Jones standard. We believe that this is grossly improper. This is not invective or rhetoric or one of these situations where maybe it's an improper inference made from the evidence. This is a direct misrepresentation of the record testimony in the case made by the prosecuting attorney in order to secure a conviction. And in that, we think that under the Jones standard, grossly improper imposes a duty on the trial court to intervene to protect the sanctity of the proceedings and the rights of the parties. And we feel in this case that the prosecutor stepped over the line, and it was necessary and incumbent upon the trial court to intervene and to curtail that practice. And it happened 3 times during the argument.
Mr. Castellan, if I could, since you raised that point, what's the purpose of the trial court's jury instructions?
Well, I agree. There is an instruction that says you're to recall your own recollection of the evidence and to not rely upon that piece of instruction is given. But again, we also have a situation where that's part of a lengthy instruction. We do presume that juries follow the law. But if a prosecutor can be mistaken about what the evidence, a prosecutor who is prepared for this case, who is trying to see, it can be mistaken, then a jury can be mistaken in their recollection too. And the Jones case, from which we derive this standard of review, quotes at length from the U.S. Supreme Court case about the special regard that jurors may hold prosecutors. And when a prosecutor says to a jury 3 times, a witness testified to the fact, and they didn't, it's not unreasonable to think a jury is going to start to think, well, maybe the prosecutor's right about that. Maybe that is the recollection.
Well, is there a difference? I'm sorry, sir. Is there a difference between a misstatement by an attorney and a statement calculated to mislead?
Well, I'm very troubled about how to characterize this statement. This is, again, there's statements that prosecutors may make in a closing argument designed to inflame the passions or to interject or maybe makes an unfair inference. But this is a direct misrepresentation of a material fact.
Okay, and what evidence is there in the record that this was an intentional misrepresentation of a material fact?
Well, I don't know that I can establish that it's an intentional, but it's clearly incumbent upon an attorney. I mean, we are responsible for the facts that we recite. That's in the rules of professional conduct. The Jones case alludes to that, the duty of candor to correct misstatements of fact.
Well, let me ask you, we started off with the jury instruction, and you mentioned that the trial court here gave it. Here's the instruction in this case that the trial court gave. Now, if in the course of making a final argument, a lawyer attempts to restate a portion of the evidence, and your recollection of the evidence differs from that of the lawyer, you are, as jurors, in recalling and remembering the evidence, to be guided exclusively by your own recollection of the evidence. Does that instruction not contemplate that attorneys may make mistakes?
I think it certainly contemplates that an attorney may make a mistake. But again, the Jones court, where presumably that same instruction was given, the Jones court talks about the duty of the trial court to protect the rights of the party and the sanctity of the proceedings. And if we're going to allow prosecutors to misstate evidence, directly misstate material evidence on the critical issue, what fairness can there be left in a proceeding at all?
Well, isn't that also partly the role of defense counsel? If it's such a critical issue, shouldn't defense counsel have made some objection?
Well, I agree. Defense counsel should have made some objection at that point. But on the other hand, if we talk about a case where trials are long, trials are complicated, it's not out of line if we're going to assume that the prosecutor maybe made a mistake, or I think the state uses the word conflated the evidence. Well, why is the mistake by the prosecutor in conflating the evidence not remediable because the defense lawyer also made the same mistake? I mean, we're talking about the fairness of a proceeding to a defendant, to an accused who is now in prison, based upon a misrepresentation of evidence by a prosecutor to a jury on the critical issue at trial.
Mr. Castelline, what would you say about the converse of your concern being true? That being that if the juror's recollection is such that it demonstrates that the state here, as the misrepresenting party, is saying something wrong about the evidence, that the jurors may somehow feel that the misrepresenting party is not being forthright?
Well, that is a conclusion that they could draw. And I, again, draw the court's attention to the opinion of this court in Jones, which talks about the special regard that jurors may hold for prosecutors. That a prosecutor, and I think Sanderson says it better, represents the sovereign, represents the people, and they are going to get some deference from a jury, especially when they make the same misrepresentation. Again, this is putting words in the mouth of an eyewitness, and made 3 times during closing argument. And if the opinion of the Court of Appeals concedes that it may have given the jury greater confidence in their verdict.
But I recollected what you said earlier, that on one hand, it may have given the jurors more confidence if they had been inclined to look at the evidence in that fashion. But haven't heard you say earlier that the jurors may be inclined to accept after 3 times that the statement was made by the witness as represented by the state, couldn't the converse be true, which is that if the jurors are presumed to follow the law, that the jurors could deliberate and say that the state, in fact, has misrepresented a statement 3 times. Perhaps their case is not as strong as they're representing it to be, and therefore that could be held against the misrepresenting party, in this case, the state.
Well, it certainly could be, but I think one of the cautionary note from this court in Jones talks about, again, the sanctity of the proceedings and the need to protect the parties and the danger of prosecutors wanting to push the envelope. And if we're going to, the published opinion of the Court of Appeals endorses a practice, makes it acceptable, entirely acceptable to directly misstate evidence, even to the extent that it gives the jury greater confidence in the verdict, then what boundaries are there on prosecutors? Again, this isn't rhetoric, this isn't invective, this isn't the the introduction of some theme into a closing argument. This isn't castigating or characterizing the defendant in a bad way. This is a misstatement of evidence, and we convict people based on evidence. And if a prosecutor is not obligated to correctly represent facts from the record, then what fairness can there be in a proceeding? I think lawyers.
As you discuss boundaries, what would be the boundary upon which the trial court must operate, assuming that, again, you're saying that ex mero motu, the trial court must intervene when there is no defense objection, and yet you would have the trial court to intervene on its own volition? Where would that boundary be reference the defense's expectation to object, and there being ultimately a plain error determination here by this court?
Well, we presume, I suppose, that a trial court judge, a superior court judge, is also responsible for, again, as Jones says, protecting the fairness of the proceeding, the sanctity of the proceeding and the rights of the parties, some duty to know if somebody has stepped over the line and started to argue facts that weren't in evidence, to intervene. They know that, and we know, again, from Jones, that the reluctance that an attorney may have to object to a closing argument because it may be perceived as interrupting the other side. But again, the actors in this scene are the prosecutor, who has a duty to do justice, a duty to not rely upon false representations, the judge, who has a duty to protect the fairness of the proceedings, and the defense lawyer, who has a duty to protect his client. Now,
Yeah, and finally, from me, I know my colleagues are being extremely patient with me, and I appreciate it. But to follow up on my learned colleague, Justice Berger, are you saying then that the trial court, since you say the trial court should intervene, since the trial court is the individual who does, in fact, determine what jury instructions are to be given, are you saying that that trial court's intervention with that trial court jury instruction is not sufficient to protect the integrity of the proceedings in terms of giving the admonition that the jurors are to rely on their own recollection if, in fact, there is, as you put it, a direct misrepresentation of the evidence in the recollection of the misrepresenting attorney?
well, if there is anything that goes over the line into gross impropriety, it would seem to be a direct misstatement of evidence. We know that prosecutors can't rely upon false testimony. Defense, no party can put forth false evidence. And yet, if a prosecutor argues false evidence, puts words in the mouth of an eyewitness, we're going to say that isn't over the line. And that's what the Court of Appeals has done. And all of the admonitions that come from Jones about, citation to the rules of professional conduct, citation of the duty of prosecutors may push the envelope. If we're going to now have an opinion of a court of appeals that says it is acceptable to misstate material evidence, to put words in the mouth of an eyewitness in front of a jury, and that doesn't constitute some degree of unfairness, that doesn't affect the sanctity of the proceedings, that seems to me that it is not, that we don't have a fair proceeding in that regard. And I understand that we give the instruction, and again, this isn't one misstatement. This is words in the mouth of an eyewitness who, incidentally, neither of the eyewitnesses identified the defendant in court. And
on this question of the trial judge's duty to intervene, is there any, and so in this particular case, is there any legal significance to the fact that the prosecutor made a similar misstatement to the court during a voir dire testimony, and similarly implied that an eyewitness to the incident had seen a chest tattoo instead of a cheek tattoo?
well, it is troubling in this case that when the photograph that was introduced that connects Mr. Parker to the event and to this false statement, when it was introduced, the prosecutor made the similar misrepresentation that it was testified to in court in order to get that exhibit represented. And again, the defense lawyer did not object at that point in time, and the Court of Appeals found that argument to be waived because it's a constitutional argument and found it to be waived. But again, it was the same misrepresentation explicitly made by the prosecutor that a witness had testified to seeing a chest tattoo.
But I guess my question is it possible that the trial court also was laboring under that misunderstanding of the evidence in the case?
Well, I think it is entirely possible that the trial court was laboring under that misunderstanding of the evidence. And I think that it's even conceivable that the prosecuting attorney was conflated the evidence. But if we convict people based upon evidence, and we have a misrepresentation of that evidence, then that seems to be an unfair proceeding by its very nature. And I think that it's that at some point, perhaps the trial judge believed that was the evidence because the prosecutor told them that. And
what do you make of the state's argument, at least as I understand it, that suggests that we don't need to be worried about this so much because there was other evidence in the record from which your client's alleged identity is the perpetrator of this offense?
Well, we addressed that in our reply brief, and I think it made some effort to dismantle the other evidence. But I think we have to remember that when we're talking about a jury trial, we're talking about fully satisfied and entirely convinced, that cases are close. And when we're talking about the fairness of a proceeding, we're talking about what does the state use to get over the finish line. And here we have a prosecutor in a case who believes that it's important to 3 times bring up a fact in order to persuade the jury. So certainly the prosecutor thinks that was an important piece of evidence to put them over the finish line, over the goal line, in this case, to fully convince the jury. The Court of Appeals acknowledged that it may have given the jury greater confidence. Cases are going to be close, and the great danger to defendants is in a close case that something unfair is going to be weighed against the prejudice standard. Says, well, there's this other evidence. And what we have
doesn't our case law require some sort of prejudice analysis here, though?
Well, I believe it does require some prejudice analysis, and I think when we talk about the prejudice analysis, we have to, I'm always wondering what is the hypothetical jury that we are employing for this prejudice analysis. There certainly is other evidence in this case that suggests he's there, but there's also the opinion of the Court of Appeals that says it may have given the jury greater confidence. We also know that it goes right to the heart of the case, to the bottom line.
So are you asking, I'm just trying to make sure I'm understanding, other than to reverse the Court of Appeals opinion, are you asking us to essentially hold that any time that a prosecutor misstates a significant fact in the case without there being any evidence that it was done intentionally or the contrary, we just don't know, that by itself requires a trial court to intervene without objection?
Well, I think that the rule that we have under Jones is the appropriate rule. And I think that it's not necessary in this case to push that rule. I think that the Court of Appeals simply misapplied the rule when they didn't follow the language that says protect the rights of the parties and the sanctity of the proceedings, when they concede that it may have given the jury greater confidence in their verdict. And if we're talking about, a fully convinced and entirely satisfied jury, that is impacting the jury's decision in this case. That's affecting their outcome.
And so that ought to be the standard that we utilize to determine whether ex merimetu intervention is required.
Yes, I think that it would require, that doesn't require us to change the rule at all. That to look at the argument, I think the Thompson case that was cited by this court in the Copley case last year talks about reviewing it in context. And in this case, it seems that the context, the thrice repeated putting words in the mouth of an eyewitness on a critical act, I think that meets that standard of likely prejudice. That affects the fairness of the proceeding. And if there's nothing else, I'd like to reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Good morning. May it please the court. I am Michael Wood with the Department of Justice. I'm here representing the state in this matter. It's a pleasure to be here, Your Honors. As stated in the state's brief, the state maintains that the Court of Appeals applied the correct standard, which is the two-part gross impropriety and prejudice analysis that the Jones case and precedent refers to. And we believe that the Court of Appeals applied that test correctly in this matter when it held both that the prosecutor's misstatements were improper and also that the statements were not so grossly improper that it would have required the trial court on its own, without objection by defense counsel, to intervene in this matter at trial. We believe that those conclusions were correct, and we are asking this court to affirm that decision. Let me turn directly to the factors that the Court of Appeals considered. And as we know from the precedent from this court, context is important, the evidence is important, and the circumstances surrounding the improper statement are of critical importance in making this prejudice determination. And here, it is correct that the prosecutor misspoke. The state did concede that at the Court of Appeals. It was not true to say that an eyewitness saw P on the porch and P had a chest tattoo. That is just not true. And it is true that the prosecutor said that same statement 3 times during closing. But I think it's important to consider the line between improper and grossly improper. And I think the Court of Appeals did just that here. Specifically, in the precedent that has been cited in the briefs, it talks about prosecutor misstatements that are calculated to sway a jury, or that cross the line in an intentional way to inflame passions or go outside the record or refer to other inflammatory kinds of matters. And here, I think it's quite clear from the full closing statement by the state that this wasn't anything close to intentional misconduct or intentionally trying to misstate evidence in order to inflame the jury. I think it's much more likely that the prosecutor just flipped a couple of facts in her head and misstated them. For example, it was true that the defendant was on the porch. We know that because the defendant, during his custodial interrogation with FBI agent Brady, said, after initially denying being at the scene, he said, yeah, I was at the scene that morning. Maybe somebody did see me on the porch. And then separately, defendant's girlfriend, Miss Peterson, did say, and the photograph did show, that defendant had a chest tattoo. So it is true that defendant, who had a chest tattoo, admitted to being on the porch at Sugar Hill Lane that morning. Those facts were true, but no eyewitness ever said that defendant had a chest tattoo and I saw him on the porch.
Does the character of that photograph make a difference in that it was only allowed into evidence for illustrative purposes, wherein the reference to it was in effect for substantive purposes during that closing argument?
Excuse me, Justice Morgan, the second or third word you said, does the what of the photograph, the status?
It was utilized for substantive reference,
Yes.
but yet it was only as a photograph allowed for illustrative purposes. To what extent does that make a difference in terms of the misrepresentation by the prosecutor during closing?
I think it does make a difference, Your Honor. There is suggestion in the prosecutor's closing that the defendant's appearance had changed between March of 2015 and the trial in 2018. And so the fact that the prosecutor was trying to get the girlfriend to identify how defendant appeared in March of 2015 and was using that photograph merely to illustrate her testimony about how he appeared on the day of the incident, I think that is distinguishable from trying to put into evidence affirmatively that there was a chest tattoo. The fact that there was a chest tattoo is really immaterial to the state's case. And the fact that the chest tattoo was mentioned, and again, I don't want to minimize it as a slip of the tongue. I think that's not the appropriate phrase here. But it was an incorrect statement, no doubt about it. But it in no way was a theme of the state's case. In other words, you can read from the closing argument in its entirety that who was P on the porch absolutely was the key issue, but it wasn't a theme that it's all about the chest tattoo. And we know that it was P because the chest tattoo was central to this case.
Wasn't the state's inappropriate statement, though, arguably exacerbated by the fact that the photograph was limited to illustrative purposes, but yet the reference was substantive in nature, such that it actually aggravates the improper statement made by the prosecutor?
I think the answer has to be no, Your Honor. There wasn't a stress placed by the prosecutor or any of the witnesses about a chest tattoo. The only reference to that was the girlfriend, and Ms. Patterson was merely describing as a whole defendant's appearance. And she mentioned face tattoo, which is important. She mentioned arm tattoos or tattoo, which is not important. And she mentioned chest tattoo, and the photograph apparently showed not a prominent, really bright or any sort of real distinct tattoo. As the trial court noted, it showed a tattoo, but it wasn't something that jumped off the page. So I don't believe that that is grossly significant here or highly probative of what the jury was considering. So my point is that from the context of the closing, I think it's explainable what the prosecutor did, and it certainly does not appear to be a calculated, deliberate attempt to go outside of the record and pull something in. And I would draw a very strong comparison to the facts of the closing in this action to the precedent. where we see prosecutors going outside of the evidentiary record to make references to suggest that this defendant was involved in a different murder, or to bring in and make argument about motive or full circumstances of what was going on when there's nothing in the record. It's not that kind of mistake.
Can I ask you first about what our precedent says about the relevance of the prosecutor's intent when the statement is, as you say, sometimes what's inappropriate is an improper effort to inflame the jury's passions, to refer to things that are not proper. But here, where it is a misstatement of the evidence, why would it matter whether, from an analytical standpoint, where the question is the fairness of the proceeding and the importance of the jury making its decision based on facts? Why would it matter whether a misstatement of a material fact was intentional or unintentional? Isn't the problem just that the jury has heard, and in this case 3 times, but the jury has heard a misstatement of an important fact?
So,
and do our cases say that? Do they say in this circumstance you have to show intent?
So I don't think the cases get into whether defendant needs to show intent or lack of intent. The Jones case does talk about the great concern where the prosecutor's statements are calculated to inflame the jury. So that does sort of speak to an intent standard. But Your Honor, I haven't seen discussion in other cases about intention versus just a mistake. I do think it needs to be factored into the prejudice analysis. Certainly if the prosecutor, as we've seen in some of the other cases, is making references to Columbine shootings or Oklahoma City bombings, bringing in facts that have nothing to do with the case in order to inflame, that's something at least correctable. And if prosecutors follow this court's guidance and have taken admonishment to not cross the line and to be really careful not to inject that kind of outside information into a closing, that's correctable. That can be stopped. Here, where it's more that the prosecutor just mixed up a couple of facts, unfortunately got them wrong and misstated them, the jury still heard it, and that is undeniably true. But I think that it needs to be considered that it's something not correctable, right? No decision that this court could write can tell this prosecutor, don't mix up the facts in your head or it'll be reversible error.
Well, except that certainly it could encourage prosecutors to be more careful about their statement of facts. But on the prejudice question, do we have any cases where a material fact has been misstated several times before a jury and the court has said, no, that's not prejudicial?
If there is such a case, I have not come across it, Your Honor, and I've looked. The ones I've seen are what I would say much more extreme scenarios, pulling facts out from the prosecutor knew something from a different trial and tries to say it in this trial, or the prosecutor is ascribing motive or other, casting aspersions. There are several cases where the prosecutor is insulting. Those are the ones that are cited in the briefs, and I've not seen one where it's just a mistake, a perhaps explainable, unfortunate mistake of fact, as opposed to an insult or an outside issue being injected. So let me turn to the prejudice analysis now. And again, we believe that the Court of Appeals correctly applied the 2-part test and correctly looked at prejudice here to conclude that it was improper, but not so grossly improper that the trial was unfair. And that's because the state's evidence identifying defendant as P, the man on the porch with the revolver, didn't relate to the chest tattoo. There are multiple other pieces of evidence that allowed the jury to reach the conclusion that defendant was guilty here. Most importantly was the eyewitness, Derek Copeland. And so Mr. Copeland was on the scene at the Sugar Hill house twice. He first arrived, there were no drugs present, so he left with his 2 colleagues, and then they came back. They were able to, Mr. Copeland testified very clearly he saw Pete on the porch. He didn't know him, but he was told his name was P. He said he had a Muslim type beard. He said he had brown skin. Importantly, Mr. Copeland identified the man on the porch as having a face tattoo on his upper cheek. That's highly significant, Your Honors. There is no evidence in the record that anybody else at this scene had a face tattoo except for the man on the porch whom Mr. Copeland identified. He also gave his body size, and he said that he saw him on the porch with a revolver. He jumped off the porch holding that gun. His ability to view to view P on the porch was so significant and so meaningful that he was able to, from the photo lineup just 4 days later, also pick out a picture of defendant. And we know from the record that Mr. Copeland identified that P was defendant with 85 to 90% accuracy. So that's very powerful evidence that the state had. It has nothing to do with the chest tattoo, but it does have to do with that face tattoo. And again, the only person with the face tattoo was defendant. There's a second eyewitness, Mr. Michael Harbin. He also saw P twice on the porch. His testimony is not nearly as specific as Mr. Copeland's. He was only able to say that he saw P wearing a hat, that he had brown skin, and that he had a beard. So that's consistent with defendant. He also says he was sort of a bigger dude, a burly dude. If the eyewitness was only Mr. Harbin, I submit the state's case would have been a lot weaker. Mr. Copeland's testimony was very important in that respect. And so was something that I mentioned earlier, which is defendant, during his custodial interview, gave a key piece of evidence. And he admitted that he was at the crime scene the morning of the crime. He admitted that he was on the porch. He said, it's possible somebody may have seen me on the porch. And he disagreed. Then the rest of his story was that he had left the crime scene before the shooting happened. So that's really key on top of Copeland's testimony identifying defendant at the scene. We know that defendant was at the scene from his own words. As to the timing and as to whether the defendant was being honest in his interview, the state introduced that evidence from FBI agent Michael Sutton. And that was the historical cell site analysis testimony, where the FBI agent showed that defendant's story couldn't have been true. In fact, defendant did not leave the Sugar Hill house between 8:30 and 9 o'clock in the morning, as he claimed. The cell phone data showed that defendant's cell phone was in Garland, in the same sector where the shooting took place, up until 9:57 in the morning. So that rebuts defendant's story. And the FBI agent's testimony further showed, although there's a gap in the data, so we don't know that any phone calls were made for that about 90-minute time period, we do know that at 11:38, the defendant was on the move, and his phone was now still in Garland, still on the same cell tower, just a little bit north of the shooting area. So that evidence was pretty compelling, and it showed the jury that the state's theory was the shooting took place at about 11:20 in the morning, and that defendant's cell phone was more likely than not to be in the shooting area at that time. All of that evidence has nothing to do with the chest tattoo, but it all does show that the state's evidence was strong, implicating that defendant was on the porch and the defendant was the shooter. And we know that defendant was seen by two witnesses with a revolver in his hand. It also appears, Your Honors, that the jury really parsed that evidence and considered it carefully. Specifically, I'm referring to the jury acquitted defendant of the three most serious charges here. The murder and the robbery and the attempted robbery charges were not guilties. And so it appears that the jury was very carefully looking at the evidence and only convicted on possession of a firearm by a felon. I also note that the defendant has made the point that there was no in-court identification and ascribes some great importance to that as a way to cast doubt on the state's presentation of evidence. I have a couple of answers to that. One is that's certainly a valid jury argument. Ladies and gentlemen of the jury, they didn't even identify this defendant as the man on the porch. They could have done that and they didn't. And so that's really important. You should consider that. defense counsel did exactly that at this trial. That was a theme of the closing argument at trial. And so apparently it didn't sway the jury because they still found defendant to be guilty of possession of a firearm by a felon. So that's an appropriate argument, and it was raised at trial, appropriately so, I think. My other answer to that is an in-court identification is certainly not an element of these crimes. And yes, the state did not ask that question, but neither did defense counsel. Both trial counsel could have, chose not to for whatever strategic reasons. And as I noted earlier, there was suggestion in the closing that defendant's appearance had changed in 3 years. So it may well be that those changes were significant enough between 2015 and 2018 that neither side wanted to ask that question in front of the jury. I think my final point, so that to sum that up, Your Honor, there was plenty, the state had plenty of evidence by which a jury could have concluded and did conclude defendant's guilt. The chest tattoo was not part of the theme of the closing. It was not part of the prosecutor's story or theory of the case. Yes, it was a misstatement. Yes, it shouldn't have been made. Yes, the Court of Appeals concluded it was improper. But in this context, against all of this other evidence, doing the full prejudice analysis, the court appropriately concluded no prejudice to defendant, requiring there to be a reversal. My final point, Your Honor, goes to the jury instructions. And Justice Berger read a few minutes ago what the jury instruction was. I will note that the court repeated that twice, actually. Once right before the closings at transcript page 937, the court told the jury, you're about to hear closings. Keep in mind, closings are not evidence. And if your memory of evidence differs, you should go with your memory. And then once again, after the closings, when the court instructed the jury, gave the same roughly the same instruction in almost the same words. So that was repeated twice. This court has held that we presume that jurors will follow the jury instructions. And so,
are you arguing that this instruction is sufficient to preclude any action by the appellate courts in any case in which it's given? Or is your argument limited to the facts of this case?
My argument, Your Honor, is that I think it's an important factor to consider that this curative jury instruction was issued in this case, and it probably is issued in other cases.
I mean, it's if you'll, I'm sure you're familiar with it. It's in the standard pattern instruction that I think is given in almost every case. I know we don't have that. That's just something that appears in the almost every set of instructions I've read.
Yep. That's my understanding as well, Your Honor. I don't think the proper rule would be every time that curative jury instruction is given, it's a free pass to prosecutors to go ahead and say whatever they want. I don't think that would be the right answer. I don't think that would be a good outcome. My response, my argument would be that the jury instruction is a factor that should be considered in the prejudice analysis. And I acknowledge that in cases, including the Sanderson case from 1994, this court has held that there are some grossly improper statements by prosecutors that are just so far out of bounds that a curative jury instruction is not going to save the day. And so it's a factor, Your Honor. I think it's an important factor, but I don't think it can be a definitive, dispositive sort of, it's not a cure-all, it's not a free pass in any way, nor should it be. And so for all of the reasons stated in the state's brief and presented this morning, Your Honor, we're asking this court to affirm the Court of Appeals. We think they did the two-step gross impropriety prejudice analysis correctly. And on these facts, which I submit are much less egregious than precedent cases with insults, pulling in Columbine or Oklahoma City, pulling it outside in things that will inflame. This doesn't seem like the type of decision, the type of mistake by the prosecutor that should lead to a decision, once again, admonishing the bar to stay within the bounds. Thank you.
Thank you, counsel. Rebuttal.
Well, I think that the important thing to remember here is that trials are about jury's opportunity to weigh the evidence. We convict people based upon evidence. I think following up on Justice Earle's questioning about does it matter whether it's intentional or not, we hold lawyers to the standard of being accountable when they make representations of facts. Lawyers have a duty to be accurate when they're making representations of facts. They have a duty to correct false representations of facts. And here we have somebody putting words in the mouth of an eyewitness, and that is a misstatement of the evidence. And a fair trial requires that the prosecutor, the state, be accurate in the representations of the evidence that they make to the jury. And I think that that's, whether it's a mistake or an innocent mistake or a deliberate mistake, I don't think there's cases that talk about that. But again, if we're not going to hold the prosecutor to the idea of correctly representing the evidence, then how can we ever ensure that there's going to be fair trials? The Jones case talks at length about the need to restrain prosecutors from pushing the envelope, from going too far. And if we have a case out there where the Court of Appeals ruling says it's all right to misstate evidence repeatedly, to put words in the mouth of witnesses, even when it gives the jury greater confidence in their verdict, and that's not stepping over the line, then there are no boundaries. There is no insurance of fairness. There is no protection of the sanctity of the proceedings if we're going to allow that sort of thing. And I think that's what we have here. It doesn't require the court to adopt some new rule. To weighing this in context, we have repeated statements where we're saying, that's what Copeland said, that's what Copeland said. And that is a misstatement of the evidence that is pretty explicit. And it's one thing to tell a jury of people to disregard the spin, the invective or the rhetoric. You know, we're all as citizens used to doing that. But when a prosecutor misstates evidence, which is what a case comes down to, weighing the evidence, then I think that is a particular kind of unfairness that we need to guard against. And that's what going outside the record, why that's dangerous, why there's rules about it, why we hold lawyers to the standard of being responsible for making factual misrepresentations. If I was in a trial and I misrepresented a fact to the fact finder repeatedly.
Counsel, you said 3 times now during your rebuttal some form of the term repeatedly or repeated. During your initial presentation, you talked about it being 3 times that the misrepresentation was made, and you said that several times. I want to make sure I appreciate the repeatedly and the repeated and the 3 times that you've constantly given us.
It was 3 times that they put the words in the mouth of Copeland, the man on the tattoo. And again, that's the way they link, because they don't have the in-court identification. The way they link Brandon Parker is through the picture that they introduced with Ms. Peterson, and they link that to Copeland's testimony, and they need that link. That's what gets.
I don't want you to consume your time. I just want to get my question out, and then you can take it for the rest of your time if you wish. But that is, I wanted to make sure that I had an appreciation for the importance of the repeated or the 3 times in terms of if we would decide to agree with you. Is it salient as to the number of times? Said another way, is 1 time sufficient so as to make the misstatement one that the trial court should get involved ex mero motu? Can there be 5 times that it is insufficient? Or should this be a case-by-case basis wherein the appellate court takes a measure of what happened during the closing statement relative to what that misstatement of fact may be?
Well, I think that the rule from Thompson that was and the standard from Thompson that was used in the Copley case, the entire context. And in this case, I think the number of times is a factor, just like we consider the instructions of the court to the jury, the number of times matters. And I think in this case, given the evidence, 3 times was too many.
Should it be a case-by-case basis? Should an appellate court measure how material the fact is and weigh that more than the number of times? Give us what you feel is as bright line a circumstance as possible.
Well, I think that it necessarily requires both weighing what the statement is and how often it's made. You know, some statements in trials are it was a green shirt when really it's a blue shirt. That's one kind of statement. There's another kind of statement where we're talking about putting words in the mouth of an eyewitness. That's another kind of statement. I think the rule from Thompson, the required analysis of the context, provides a way to balance all of those things with each other. And here, what we have is both the nature of the statement itself, which is putting words in the mouth of an eyewitness, and the fact that it's repeated several times, which I think goes to the context, the prosecutors feeling that they had to repeat that to keep drawing that connection repeatedly. And I don't know that we could say it's 5 times or 2 times. I suppose there's some statements that probably less than 3 times would make. But I think it's weighing the substance of the statement and the number of times it's repeated. And again, looking at Thompson, which again was the standard this court used in the Copley decision last year, which is weigh the context within the entire argument. And here we have a case that the state wants to argue that it's a strong case, but again, the jury on this same evidence acquitted my client of the more serious charges. This was a close case. And on this close case, a prosecutor misstated material evidence on the critical issue, and the Court of Appeals says this repeated invocation of eyewitness testimony that may have given the jury greater confidence in the verdict doesn't step over the line. And that to me seems to be an unfair proceeding. And my client is in prison based upon that proceeding. And I think that we need to follow what Jones says, and we need to make sure that prosecutors aren't pushing the envelope. And when they make a false statement about a material issue and falsely represent evidence, that gets corrected. And that's what I think we need to have happen in this case. And if there's no further questions, that's all I have.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now in recess. God save the state and this honorable court. Thank you, counsel.